Hi, small business owners. It's Harpreet Singh from Western Law Firm. So, while talking about the marketable title, the different issues which shows up during your transaction, and you have to make sure that you're getting marketable title with disclose exceptions. And so, the next topic or the next issue which can come up is the CC&Rs, which is covenant, condition, and restriction. So, what's the CC&R? So if suppose some developer has decided to have a planned development, it may be a residential development which you call as your residential subdivisions, or it can be an industrial park that someone want to create a plan and a common development for a piece of big property and want to build up few houses or few commercial buildings in that property and want to have some kind of an established system or some kind of common restrictions on this particular piece of project. So it's mostly created if you want to just create like a small town of in itself, like you have these rules of state, then your county, then your city, and within the city like kind of a small city, you can say. So if you want to build like that, then you need to draft those rules, and those rules will be called as CC&Rs, and you have to record those rules with county recorder's office before you sell those piece of lands. So that's the basic, I think, of a CC&R, or how to plan a development. And usually whenever you're buying home in a residential subdivision, your developer has already recorded a piece of document, and then there is a whole lot of process which goes on with Subdivision Map Act and also subdivision maps, and the solicitation or the sale of those lots, and what kind of roads and improvements or grounds which you will be getting. So all those mentions in the subdivision maps, and we will, I think, do a series of videos on about Subdivision Map Act and also how that process works out. So at least you get basics of how the subdivision comes into being. So the next topic on CC&R, why it's important, because these are restrictions and conditions on your title. So, and it's a significant restrictions, because most of these are many restrictions mentioned in CC&R. So it will substantially affect the marketability of your land, and so it's significant. So mostly it's recorded before the lots are developed. If suppose there comes, most of the time I have heard that that the CC&Rs are not even mentioned in your deed, because sometimes it happens. So how the law will deal with that? So if suppose the CC&R mentions a plan unit development, and it just mentions that it affects all these lots, and specific lots are mentioned or their APN number, legal description, regardless if suppose those are not mentioned in your actual deed which you receive of an individual lot, unfortunately you will be thinking about, okay, it's not disclosed on my deed, so all these restrictions should not be applied. But unfortunately it applies to you, because law is in a situation that a constructive notice was provided to you basically when the CC&R was recorded, and now you are doing this transaction afterwards. So it's your responsibility to look the public record, and so it would be considered as that you already have the notice, which is called a constructive notice. And so even if it's not mentioned in your deed specifically, then also all these condition, restriction, and covenants are your problem now basically. So it's really frustrating for an average person to understand that, but still that's the law, and it would be your burden, and you have to live in that property based on these restrictions and conditions. But the main important thing is that the seller has a legal responsibility to disclose about these CC&Rs to the buyer. Seller has to provide the CC&Rs and have to provide what's going on with the CC&Rs. And usually I think, so the best thing probably about homeowner associations. So those are based on your CC&R. So a homeowner association was established so that the CC&R can be implemented and can be enforced throughout these lots. So you usually see those homeowner association in your residential subdivision. So those can be similar to if the CC&Rs are on a shopping center or an industrial park. So the same thing will work out. There would be some kind of an association or a group or a board which will oversee the implementation and enforcement of these conditions. So now you would be thinking, okay, how far these restrictions can go? So these restrictions cannot conflict with the laws. They cannot conflict with the state law, the county ordinances, or your city ordinances. So they can be more restrictive if suppose your city is somewhat broad. If suppose your city has an ordinance that we will allow you, suppose, to keep 3 dogs. But this restriction cannot say, okay, we will allow you 10 dogs because your city ordinance is paramount to your CC&R. They can restrict you to 1 dog. So it can be more restrictive, but it should not be conflicting with your city, state, or your county ordinances. So this is about the CC&R, and I think again this is a much more extensive topic. We can, I think, do series of videos, and I intend to bring you videos about the homeowner association, their reach, and what are the rules which govern homeowner associations, and what are the issues when you're living in an association or if you have disputes. So how to make sure that you're following those rules, otherwise it's thousands and thousands of dollars of cost you have to bear through different assessments. But remember, the CC&R is again one of the issues to look at when you are reviewing if you have received a marketable title or not, or if your seller are disclosing you all the things which you need to evaluate the marketability of your title. So in the next video, we would be talking about several other different issues, either it's adverse possession or encroachment. So see you in next video. Again, work hard, work smart, and if you have any legal issues about real estate, business law, or employment law, let us know, and we will talk with you and see if we can help you out on that. Thank you.